Hello and welcome back to my YouTube channel, my friends. In this video, you will be learning about research methodologies and intellectual property rights, wherein we will be covering the topic process of patenting and overview of the industrial design. So, as told earlier, introduction to intellectual property, that is IP, is going to be explained now. So the definition of IP is that it is a property that protects the creations of a human mind. As the word intellectual says, it is something that is developed from the human mind. So protecting your own intellectual property is a very much mandatory aspect. However, there are different types of protection for these intellectual properties. So these are patents, which is done for inventions, industrial designs. These industrial designs usually focus on the aesthetic aspects. We also have trademarks and copyrights in case of usage for commercial use or entertainment. So the importance of these intellectual property rights is that it will encourage innovation and it will provide legal protection to whatever you have made contributed to a product as an inventor. So what exactly is a patent? We have all heard the word patent a lot of times. So when you need to theoretically define the word patent, it means that a patent is a legal right granted to an invention providing exclusivity for a specific period of time. So a patent is usually granted to a person in case they found out a new invention for a new product which is not existing, and this patent will provide protection to their product design for a specific period of time, that is say 5 years or 10 years, based on their uh, renewable period. So the features of a patent are that it must be novel, non-obvious and industrially applicable. So the patent is given only to the products that are novel and original, wherein if you need to get the patent to a product you have invented, you need to make sure that that product is not already existing in the world. Hence, it should be original, that is made by you. It should also be industrially applicable, that is, it should give some benefit to the industry. It should make some, um, how do I say it? It should be some useful aspect in the industry. So another feature is that it should be valid for a limited duration. So it should be valid for say 20 years or 10 years usually. So the features of the patent also include that the patent will prevent others from making, buying, using or selling the invention that you have made without your permission. So making a patent will prevent all these and give protection to the product you have designed. So the patenting process is a, a long process which can be explained step by step as I've showed here. So the first one is the idea and research. To get a patent, you need to first develop a product which is novel, original and is not existing already. Hence, idea and research is very important. So to generate the idea, you need to develop a unique and innovative concept about a product you want to invent, and you should conduct a prior art search to ensure originality. Prior art search is nothing but digging deep into the already existing materials in case of your product. If existing, you need to make a new advancement in your product, ensuring originality and made some unique and innovative invention. So the second step is drafting the patent application. Once you have done with your prior art search and made your uh, research that your product is not existing already and it is original and novel and unique, you need to go on with applying for the patent application, which is drafting for the patent application. So to draft this application, you need to prepare detailed specification and claims of your product. It should include drawings and descriptions and tables that will describe what exactly your product is to any layman. The third step is filing the application. Once you have accepted about the fact that it is not yet existing and it is original, you need to make a draft of the patent application. Once applied, you need to file the application in an official way. So you need to file it with the relevant patent office, be it USPTO or EPTO. You need to choose between a provisional patent or a non-provisional patent. So the patenting process, after you have applied for the patent application, here are the processes that will take place for your patent, whether it should be given to you or not. So this question will be answered using these steps, wherein examination process is going to be conducted. So the patent office will review the application for compliance and originality. So they will check whether your product is new or it is already existing. So it will respond, the patent office will respond to any objections if there is any. If not objections, we will go on further, wherein we will grant the patent to the user, that is you, who has developed the patent and who is the inventor of the product. So once approved, the patent is going to be granted. However, after granting, we need to maintain this patent application which is already got using renewal fees, wherein you will be renewing for a few years or a few specific period of time. So we need to maintain it by paying renewal fees regularly, so that the patent does not get expired. There is also a question of enforcement here. So we can take any legal action against the infringement in case of using our product for buying, selling, or any other commercial purpose, in case we have the patent renewed and very well protected. What exactly is industrial design? When once done with patent, we need to know what ID is. So protection of the ornamental or aesthetic aspects of a product is very important. So this is done through industrial design. As told earlier, industrial design mainly focuses on the aesthetics originality. So the key features of industrial design are that it will cover the visual appealing, that is the shape, pattern or color. It does not protect any technical functionality. So the importance of the industrial design is that it will enhance the marketability of your product and it will build a brand identity. Examples of industrial designs are household products like furniture, cutlery and appliances, fashion like clothing, jewelry and accessories, and technologies like smartphones, cars and packaging. So a real life example is the iconic design of the Coca-Cola bottle, which was copied by another company called as Pepsi, wherein the Coca-Cola people had already applied for the patent for their industrial design and they won the case. Here is the difference between patent and industrial design. So when we see the aspects, the focus on patent will be on functionality or technical innovation. However, industrial design will focus on only the visual appealing to us or the aesthetics. The protection duration for a patent will be 20 years, that is the subject for renewal. However, for the industrial design, these years of renewal will vary by country, but here it is 10 to 15 years. The scope of patent is basically on the process or method in manufacturing a product. However, in industrial design, it is about the shape, pattern, color, or the ornamentation used. So the benefits of patents or industrial designs are given below. So the patents will encourage innovation to an individual, wherein it provides competitive advantages and enables monetization through licensing of the patent. So using that patent license, you can give it to trade or e-commerce websites where you will be earning a lot of financial income using your patent license, where you will be using it for commercial purposes. So industrial designs are another benefit as they increase the product attractiveness, they will strengthen the brand recognition, and they will also support the market differentiation. That's all for today, my friends. We'll be meeting on more such contexts. Until then, thank you.